And the floor is yours.
Thank you, and we appreciate the opportunity to speak with you. We would be happy to take any questions that you have during our presentation. What we have discovered is that the audience we've spoken to over the last week and a half between China and mainland China and Hong Kong has been incredibly sophisticated and very much interested in the export controls implications, and in particular in the Huawei action within the United States. As a result, we're going to invert the presentation, so we're going to start with export controls and then move into sanctions. But if there are questions that anybody has, what we found is that we're more than happy to take the direction that the audience would like to go. So with that, I'll turn it over to Chris, my colleague.
Sure. So I'm going to move down the slides a little bit to the export control section, and then we'll go back. So, we have a slide clicker? Oh, great. That makes sense. So, U.S. export controls have obviously become a hot topic of late in mainland China with the recent designation of Huawei, and in recent years the designation and the penalties against ZTE. With that said, we've been giving this presentation, and again, to Cari's point, if you have questions specific to some of those issues or to recent events, we're happy to talk about them. But right now, I'm going to present sort of an overview because I think a lot of people that we've spoken with have very particular knowledge about the implications of these recent actions, but not a lot of knowledge about the framework, the legal framework from which they come. And so the idea of this presentation is to give you a little bit of that general background about U.S. export controls, to understand some of those recent developments. Specifically, one thing I think you'll take away, and one thing that's become fairly obvious because of the Huawei action, is that the jurisdiction that the U.S. exercises when it regulates export controls can be extraterritorial, much more so than any country's export control regime that I'm aware of, particularly those in the West. Also, what's become apparent because of recent action is that technology moves faster than the law. The technological advances that are happening in the telecom and other industries are outpacing the U.S.'s ability to regulate and govern and protect its national security in the way it believes is adequate. And so you're seeing a tension between the law and technology. You're also going to see that these laws are rooted in national security, meaning that because it is such an important aspect of U.S. governing, that it protects its national security, that it has it can quickly implement changes to export controls that are very restrictive at sort of a low bar. And to date, that's usually been exercised in one manner, but what we're seeing now is that there's some correlation between the exercise of U.S. national security policy through export controls on the trade negotiations between China and the U.S. And so it's really an interesting tension there as well. So the background of U.S. export controls. Export controls, and this presentation also touches on sanctions, but export controls and sanctions are different in that export controls govern the movement of items and technology. Sanctions tend to deal with transactions and financial transactions and services, but export controls are really related to the movement of goods, technology, and also software. And they're done so, again, from a national security perspective. They're primarily based in the control of military technology. The U.S. wants to regulate the ability of its adversaries to have access to sophisticated technology that could be used against the U.S. And so there's laws and regulations in place to limit that. But in addition to military technology, it governs dual-use technology, which is a phrase we use in the U.S. to mean technology that has a military capacity as well as a civil capacity, right? So there might be a commercial application for your technology, but the military might have use for it as well. And so depending on how sophisticated it is, controls are put in place by the U.S. Export controls are based on destination, but they're also based on end use. For instance, the U.S. has a foreign policy goal of halting the proliferations of weapons of mass destruction. So if you're exporting goods to further that purpose, it's restricted. And then they have end-use controls or end-user controls on particular actors or entities that they believe are acting contrary to U.S. national interests And that's where Huawei comes in, frankly. And these laws and regulations carry penalties. They can be very severe penalties. For civil violations, they can amount to double the transaction value or somewhere around $309,000 US per violation. The settlements recently have become larger and larger. The trend that we see is that companies are being penalized more and more severely under these laws and regulations, and we don't see that trend changing. The ZTE case amounted to $1 billion in paid fines and another $1 billion in suspended. So those are tremendously large fines. Obviously, we're talking about real money, as someone said at one of our presentations. And there's other penalties that are carried with it. For example, if you were to find yourself, as ZTE did, or as other entities that have settled these large fines, those things are made public. Those are in press releases. Companies obviously want to avoid that public scrutiny of their business activity. And the government's very purposeful about the fact that it wants to, in fact, sort of shame companies by making these things public. In addition, companies will be subjected to significant compliance measures that are forced by the U.S. government. You might be subject to monitors, you might be subject to audit requirements, you might be required to implement expensive technological solutions for screening parties and products. So all those things are possible penalties that can arise out of overstepping or outstepping these violations, or these regulations. There's
on that, we've heard the discussion of strict liability under these regimes. Can you talk about what that means and what that means both sort of under the statutory scheme and then in practice?
Yeah, so the question is about strict liability, which is a legal phrase that you hear associated with these regulations. And what it means is that in order to penalize someone under one of these laws and regulations in the U.S., the government doesn't need to show that that person knew what they were doing is wrong. All they have to show is that the activity occurred. So if a company in the U.S. is deceived by a reseller or a distributor about where their product is actually going, if a company is not sure of how sophisticated its technology is with respect to these laws and and where it should or shouldn't need to get a license, if a company misunderstands the requirements for exporting to Huawei under the entity listing, and does so in good faith, if they're not trying to be a bad actor, they just made a mistake, they're liable for the penalty. The same way a company that might that maybe exercised reckless behavior or maybe knew or had reason to know something was wrong with that. So that's a tremendous deterrent, right? And what the U.S. government really hopes they get from that is that companies will spend a lot of effort and time and resource and money on compliance. Because if a company can demonstrate to the government that it's exercised careful compliance in a risk-based manner, then that's going to be its best defense, because the government sort of already has you, right? You've already have the violation if they found out, and so at that point, really your best defense in the face of that is to demonstrate to the government that everything you did leading up to that was reasonable. You looked at your risk in a sound, reasonable way. You put in compliance measures to mitigate that risk, and maybe you were deceived by a bad actor reseller, or maybe you made a very good-natured mistake and you can correct it and move forward. But companies are put in a very difficult position because of the fact that these are strict liability. And then there's criminal penalties. So in addition to being penalized civilly in a strictly liable manner, if you act willfully or with knowledge that something is unlawful, it can be raised to a criminal standard where you can be prosecuted criminally for these violations. And individuals within companies, in fact, the Department of Justice in the U.S. Has specific initiatives and specific memoranda instructing it to look at punishing individuals specifically criminally when there's criminal behavior. So individuals and companies can be found criminally liable for these types of violations as well, and those carry very, very severe penalties. Under federal criminal statutes, 20 years is a very long sentence, and it does carry a potential 20-year sentence. So why am I talking about U.S. law in Hong Kong? Right? And the reason is that one of the takeaways that we hope you get from this presentation is that these laws carry with them the U.S.'s view of its jurisdiction applying extraterritorially. The U.S. export controls in particular, they apply to U.S. persons. I think that makes sense to almost everyone. They apply to me wherever I am because I'm a U.S. person. They apply to Cari in the same way. They also apply to a person who is in the U.S. I think that makes sense as well, although it can sometimes be surprising to know that if you're from Hong Kong and you're traveling in the U.S. for business and you start answering emails to supply orders for people that might be unlawful under U.S. law, you'd be subject to U.S. jurisdiction. So where you are matters as well. Then the thing that will really carry jurisdiction across the border, however, with respect to U.S. export control laws, and the thing that frankly is very unique among, in particular, Western export control regimes, is that the U.S. will govern what they call re-exports. And so if an item is either originates in the U.S., travels through the U.S., or incorporates a certain amount of controlled U.S. content, then that item is subject to the U.S. export controls even after it's left the U.S. So that's a little bit different than most export control regimes. But effectively what that means is, as a U.S. party, I can't send my things to Canada to then have them sent to Cuba, for example. That would be considered a re-export from Canada to Cuba, and it's governed in almost the exact same manner as the original export would have by the U.S. government. Again, a very extraterritorial application of law. Now all of a sudden the U.S. is exercising its prerogative and its national security interests in a real way over a Canadian exporter. That's obviously come up with Huawei, because Huawei is under a very strict export licensing regime under U.S. law. And so I have found that the people I've been speaking to here in Hong Kong as well as in mainland China have a very sophisticated knowledge of what triggers those U.S. export controls for their exports or transactions with Huawei by necessity. Of course they do, right? That these are new rules and regulations. They're very publicized, and the penalties are very severe for getting it wrong. And your U.S. suppliers are probably interested in your compliance and your ability to not put them in harm's way with regard to these regulations. So that's another way that we're seeing this sort of extraterritorial application of U.S. jurisdiction. I think that covers that slide. Another focus we're seeing from clients, and again, this relates to Huawei. It would relate to any export to anyone that might be controlled from the U.S., but obviously Huawei is the topic of the day, is this thing called General Prohibition 10. Within these regulations, there are 10 general prohibitions. They save the best for last. General Prohibition 10, sometimes people will call it GP10. This one is not strict liability. This requires knowledge, either active knowledge or constructive knowledge, like you should have known. But if you have some knowledge that an underlying export was done in violation or will be done in violation, then within the regulations, there's theoretically the ability to penalize you for assisting, facilitating, servicing, or doing almost any service in regards to that unlawful export. So this comes up with questions all the time now about people who want to work with Huawei and understand that there's a very strict licensing regime and a lot of prohibitions and a lot of uncertainty. And they want to know, is my working with this supplier of Huawei, or is my selling of a Huawei device when I know that Huawei device is being loaded with Android software, is that a violation of General Prohibition 10? And the facts are very important to that analysis, but we've seen that answer come out a number of different ways depending on the facts. Again, another extraterritorial application of U.S. jurisdiction, because that could theoretically govern what a company in Hong Kong is doing vis-a-vis its U.S. suppliers and Huawei. The other thing that makes this listing of Huawei and this extraterritorial jurisdiction so complicated is that U.S. exports don't just govern the export of items. They also govern the export of technology and software that relates to these items. And so if I were to export semiconductor products, that's one thing. But if I'm also exporting production or development technology required for those same items, then all of a sudden the technology I'm exporting is controlled as well. And where companies are really running into compliance difficulties is it tends to be easy to understand where a product is going, where it's being exported. It tends to be easy to comply with rules and regulations because you can put a checklist on the door and nothing goes through the door unless it meets all the steps on the checklist, and it's sort of an easy process. However, technology can be transferred in very intangible ways, right? We can transfer technology on my phone. I can transfer technology through this microphone if I really was smarter and had some control technology I could reveal. So with that said, compliance programs really struggle to train people, to put in IT protocols, to understand the nature of the technology they're working with, to understand the nature of their software, right? We talked about re-exports of U.S. items being controlled. Well, where does your software that might be going to Huawei or some entity or some destination, where does your software come from? Was it written on a Microsoft platform? Did you have Silicon Valley developers involved in the writing of the code? All of those questions become very important when you're trying to understand what regulations and rules apply to my patching and sending updates to software to my customers, even in transactions that are otherwise outside of the U.S. entirely. We're in Asia, and I think that the trade talks highlight this, but the fact of the matter is that the U.S. has taken increased focus on China. And this is really specific more to mainland China, but the Department of Justice has come out since 2018 with a publicized initiative to bring cases against the theft of trade secrets and national security-related export controls into China by individuals and companies. And so this quote here is essentially from the press briefing about the indictment of a Chinese engineer who was taking company secrets and technology into China and doing so willfully. And so he's being prosecuted criminally by the U.S. Department of Justice. And there are a rash of these indictments in the past few years because there's an actual initiative with the Department of Justice, Bureau of National Security, to look at this and to look very hard at this. So it is not just Huawei. China is a focus for U.S. export controls. In addition, there was an executive order issued around the same time as the executive order that put Huawei on the entity list. And that executive order is titled the Executive Order Securing the Information and Communications Technology and Services Supply Chain, which is not very easy to say very fast, but what it is essentially an executive order that requires that the U.S. government come out with rules. And it hasn't come out with them yet. Right? They're supposed to come out this fall. But essentially, these are rules and regulations that are going to potentially stymie or stop a lot of the sourcing of Chinese origin and other sort of foreign adversarial countries' origin technology products. They'll do so probably through a list of some sort of prohibitions. Probably they will probably list entities associated with these supply chains that are problematic or worth more review or diligence. And in some people's sort of estimation, it might result in a framework where under these rules and regulations, U.S. companies who want to engage a supplier like this might have to put that transaction in front of the government for review, much like the CFIUS regime, which is a committee when there's foreign investment in U.S. industries that implicate national security. There's a review by multiple agencies to see whether or not to allow, prohibit, or implement certain mitigation to allow those investments to happen. We think there might be a sort of miniaturized version of that CFIUS review associated with supply chains in this space. We don't know yet. Those regulations have not been published to date. I have some folks that have seen preliminary drafts, and they change wildly between drafts. So I don't know that they've really settled on an approach at the Commerce Department. But nevertheless, those clients that we work with that are concerned with how do we continue to source to Huawei and what are the rules for Huawei, they can be complicated, but as of today, I could probably give you an answer if you were to give me your facts and circumstances. What I have to caution clients about is this set of rules coming out promises to potentially change that answer for some of our clients in the very near future, and it's something that I really want to make sure our clients are aware of and are planning for as best as possible. In addition, there's a promise by the U.S. government to further control emerging and foundational technology. A lot of people, there's a number of different categories of that technology that have been listed as examples, things like artificial intelligence and neural networks and 3D printing. That's another set of rules, or perhaps a supplement to the existing rules. We don't know yet what shape it'll take, but those are forthcoming as well, and those will likely change the way that industry and businesses in the Asian space are dealing with these extraterritorial U.S. rules that are now getting into all these emerging and new technologies where they might not have had a regulatory requirement before. I think I probably am going to move back and let Cari talk about sanctions, which is sort of complementary legal and regulatory framework, unless it makes sense to also take some questions before we shift topic.
All right, so I will do a very quick overview of U.S. sanctions. There's parallels to what the European Union does and what the obligations are under the United Nations. But given that the United States is the most aggressive with respect to enforcing its sanctions regime, its sanctions programs, I'm going to primarily focus on the trends that we're seeing in the U.S. sanctions space and what it essentially means for cross-border trade, especially where you've got a business sitting in China or in Hong Kong. In much like what Chris was saying, the United States gets jurisdiction in its sanctions regime by applying the rules to U.S. persons. And so, in general, a U.S. person is going to be a U.S. national or green card holder, any U.S. headquartered business, and then any foreign branch of a U.S. business. And with respect to the Iranian and the Cuban sanctions regulations, it also will apply to foreign subsidiaries of U.S. businesses. There's a separate way that Treasury gets jurisdiction, and that is where a non-U.S. person causes a U.S. person to violate the sanctions regulations. So Chris was talking about the very large penalties that we saw in some of the export controls cases. And in the sanctions space, we've seen the same thing in the sense that BNP Paribas was subject to a $9 billion fine. Those fines are not against the U.S. BNP Paribas branches or offices. They're against the non-U.S. headquartered entity. There has been a whole slew of them with respect to the European financial institutions, some Australian banks, and increasingly the target is the Asian financial sector as well. And the theory behind those transactions are that those non-U.S. headquartered financial institutions were seeing ways to profit, specifically in doing business with the Iranian sector in U.S. dollars, and that in order to do that, they had to hide or disguise from the U.S. correspondent financial institutions the identity of the Iranian parties. And so that activity is known as the stripping cases in the sense that the Iranian information was stripped out of the transactions and they flowed through the United States. The United States Treasury Department was able to get jurisdiction over these non-headquartered financial institutions because there's a provision within the primary statute that the Department of the Treasury uses for these national security sanctions programs that allows the imposition of sanctions on any person, regardless of location, where there's a causation of a sanctions violation. So as Chris was talking about, the sanctions regimes are strict liability. That means that the U.S. correspondent banks that were processing those dollar transactions on behalf of the large European financial institutions also could have been subject to very hefty penalties. But because of prosecutorial discretion, so the choice that the Department of Justice and Department of the Treasury made, instead of going after the U.S. financial institutions for processing these transactions somewhat blind, they went after the non-U.S. parties that caused the violations. And what has happened to the European financial institutions, starting really in 2005 against ABN AMRO and then proceeding through close to a dozen financial institutions, is what we're also expecting to start to happen in the manufacturing space and in the other services space. So we're seeing it in insurance, we're seeing it particularly in the maritime space, where there's this expectation not only that U.S. entities will have robust compliance programs, much like what Chris was saying, the expectation is that they're risk-based, so that each U.S. headquartered entity will take into account its risk exposure by customer, geography, service, and product, but also that non-U.S. entities that have a touch point to the United States, so because they use U.S. dollars, because they use U.S. origin goods or services or technology, or because there's some other nexus to the United States, like a preference for doing business in dollars, that will trigger the need, from OFAC's perspective, the Department of the Treasury's perspective, that these non-U.S. entities also will have risk-based compliance programs. And so that's essentially how the Treasury Department is asserting jurisdiction over transactions that seem completely outside of the United States. There's generally three types of sanctions programs. There's the old-fashioned embargo. So what we have against, what the United States government has against Iran is the traditional, very broad-based territorial restriction. So the United States maintains broad embargoes against Iran, Syria, the Crimea region of the Ukraine, against Cuba and Syria. There are two other types of sanctions programs, and you've often heard the United Nations and the European Union refer to these as the smart sanctions. So the sense is that you're not punishing an entire group of people for the activities of its government like you would in the Iranian context, but you would do a list-based sanction. So this is similar to what you see in the entity list against Huawei, except it's much broader in the sense that if an entity or an individual is put on the Department of the Treasury's specially designated nationals list, it means that no U.S. person can engage in any transactions directly or indirectly with that party. Much like the European Union, the U.S. government also has a 50% rule. This means that if there's an individual or an entity on the SDN list, then any entity that's owned 50% or more by a listed party is also off limits. So oftentimes, colloquially, you'll hear these referred to as shadow SDNs. And the reason why they're called shadow SDNs is because there's no way that you would necessarily know. There's no list you can go to see where the corporate family tree is of entities that would be owned 50% or more by an SDN or by a party on the EU list. What this means is that the global economy essentially has been deputized to have robust compliance programs in place. And this is where you start to see the regulatory regimes merging together in concepts. So the financial institutions for a long time have been familiar with the idea of customer due diligence, know your customer, and know your customer's customer. Increasingly in the manufacturing space, in the maritime space, in the insurance space, this is also the expectation in the sanctions world. Because it's not just enough to know that you're dealing with a manufacturing facility in China. You also have to know whether and who owns that entity and whether or not that party is either on the entity list, which may raise red flags, or is on the United Nations list, the EU list, or the U.S. sanctions list. Increasingly, what we've seen is that although OFAC has published its framework on May 2nd that applies specifically to U.S. companies, when non-U.S. businesses are engaging in transactions, the Department of the Treasury is also asking these non-U.S. businesses whether they also have reviewed the framework and have taken into account the need for a risk-based written compliance program, what types of audit functions they have, and how they're looking to protect the global financial system from exposure to sanctioned parties. There's another type of sanctions regime. So we have the broad embargoes, we have the list-based sanctions, and we also have what's called the sectoral sanctions. Sectoral sanctions are also present in the European Union in the sense that what they do is they identify an industry sector or group of entities or individuals who are subject to restrictions, but only for certain types of activities. So we see this in the U.S. sanctions targeting the Soviet Union or the Russia and the Ukraine with specific respect to what has happened in the Crimea. And the idea there is that the oil and gas sector in Russia is high risk. Rather than saying that the entire sector is off limits for U.S. parties, only certain types of activities are off limits. So those relate specifically to deep water drilling, to fracking, and to unconventional types of oil and gas extraction. So not all oil and gas companies in Russia would be off limits, just certain types of activities. There's also a concept that restricts the extension of debt or credit beyond a certain number of days. This is a similar concept to what the European Union does. What you can see from this trend is you go from having a broad ban on doing business with a particular jurisdiction to very nuanced restrictions on doing business with shadow SDNs or engaging in types of activity with specific industry sectors where there may be layers of types of financing or transactions involving a particular sector that require a very robust compliance program. And so essentially what's happened under the U.S. and the European Union schemes is if there's a business engaged in cross-border transactions, this concept not only is in knowing who the counterparty is, but also in really understanding the nature of the transaction and any of the financing and related services that touch upon those transactions to determine whether it would trigger some sort of obligation with respect to the sectoral sanctions. So we've talked a lot about primary sanctions, which are those that apply specifically to U.S. parties or to European parties. And the other type of sanction that has been getting a lot of press lately is this concept of secondary sanctions. This is what a lot of non-U.S. parties refer to as extraterritorial application of the U.S. sanctions. And these are secondary sanctions appear both in the Russia context and in the Iran context. And what they do is require that the non-U.S. parties essentially choose between doing certain types of activities with parties identified in Russia or with the Iranian government or with the United States. This is playing out in the press, most recently with respect to the government of Turkey. So Turkey recently has announced that it's going forward to buy its missile defense system from Russia. Under congressionally mandated sanctions in the United States, within the United States, there is a requirement that sanctions be imposed on any parties that are engaged with the military-industrial complex in Russia. The president has already come out and indicated that while he's aware of these mandatory sanctions, Turkey has been an ally for a long time, and there's not an indication that these secondary sanctions are forthcoming. On the other side of it, we see that the secondary sanctions have been implemented against a Chinese entity for dealing with Iranian petroleum in the Iranian context. So to a certain degree, what we're seeing is that the secondary sanctions are playing out, but there's a little bit more of a political nuance between how and when they will play out. So again, the implications for the compliance function in the global space is to have a certain amount of sophistication, not only with respect to what the regulations require and who the counterparties are to a particular transaction, but also with the political wins and with respect to the particular goals, the foreign policy objectives of the United States or of the European Union. We've talked about the extraterritorial effect, but what is also significant, and we've seen this play out really since 1996 in the European Union and also with respect to Canada and increasingly in other jurisdictions, is this concept of a blocking statute. So it applies specifically in the context of the U.S. sanctions against the government of Cuba. But what's happened is because those sanctions are deemed to be extraterritorial by a lot of U.S. allies, the European Union and Canada have responded by implementing rules that specifically prohibit Canadian or European nationals from complying with the extraterritorial implications of the Cuban sanctions. So increasingly what we're seeing, and we're seeing it play out as well in the data privacy realm, is that if you're a global business and you've built out a compliance program to take into account U.S. or European Union sanctions, it doesn't mean that you're in the clear. It may mean that you need an additional analysis with respect to whether there's also a conflict under local law for data privacy reasons or because of the presence of a blocking statute. So essentially, what we're saying is that the world we're living in now is increasingly complicated, and there needs to be an understanding of both the political atmosphere and the sanctions, export controls, corruption and anti-money laundering regulatory scheme in order to, before stepping into a new transaction or into a new economy, building out the compliance risk and then, to the extent you can, mitigating it. The mitigation is incredibly important because, as Chris mentioned, it becomes your primary form of defense in the event that there is an investigation from the Department of Justice, from Commerce, or from the Treasury Department with respect to sanctions or export controls or money laundering violations. And so I think that the Huawei example is an interesting one in the sense that it's purely an export controls issue that has taken on a foreign policy implication. But in the sanctions realm, we also see that the regulatory regime can be one that has practical implications, and often can take on a very political role as well. So,
yeah, I mean, just to add to that, in particular with Huawei, Huawei was listed on May 16th. Immediately thereafter, it was widely reported in the press that all sorts of suppliers to Huawei were going to stop supplying things like Android software, like chips. And so with that, there was quickly a general license issued, which doesn't usually happen for entities on the entity list. I don't know of it happening before, actually. And the general license allowed for some of these activities for a certain period of time. After that, the G20 meetings happened. And President Trump came out and said that, look, there's got to be a way to let U.S. exporters continue to sell products to Huawei. So then the Secretary of Commerce came out and said, well, we can't change that Huawei's on the entity list. There's a lot of regulatory and legal hurdles to doing that. And they were put on that list for national security reasons, not as part of the trade negotiations. However, the Commerce Department said in public statements they're going to issue licenses so long as the exports to Huawei don't implicate national security. And they've not been very forthcoming with guidance as to what that means. So we're seeing a lot of approaches to putting those licenses together. We're helping a lot of clients with those licenses. And I think in the next couple of weeks, we're probably going to start to see what that really means when we see what's being granted and what's not, what the Commerce Department is receptive to and what they're not. And seeing whether or not that general license that they issued maybe gets extended. And you know, everyone's watching the negotiations in Shanghai to see if there's movement on that, right? Are there further statements about relaxation of that as some sort of concession from the U.S. to the Chinese in the trade negotiation? I don't have an answer for you, but that's certainly what we're watching for.
So, I mean, we've spoken a lot, and I think we'd be more than happy to take any questions that anybody has with respect to export controls or sanctions, or any of the other issues that we've seen playing out over the last couple of weeks between the negotiations between the United States and China.
Please.
Yeah, I have two questions basically about the personal liability in sanction schemes. So compared with anti-bribery corruption, I know a yes memo was issued by the DOJ. So compared with ABC programs, I understand the Meng Wanzhou, the chief financial officer, was captured in Canada. So in terms of sanction penalty schemes, what's the personal liability, was based on the U.S. sanction schemes. So the second question from me is that in April this year, the DOJ published the corporate, evaluation of corporate programs, right. Compliance programs. So I suppose these should be suitable, applicable to the three programs, ABC and AML and sanctions. Right. So compared with the ABC and the AML compliance programs, what are the unique, features of sanction schemes compared with the other two? Thanks.
Yeah, it's a fantastic question, because I think what we've seen over the last maybe 20 years is that the separate regulatory streams, so you have anti-money laundering, sanctions, export controls, and anti-corruption and anti-bribery, there's been a convergence. And a lot of this happened because right after 9/11, the Department of Justice set up a national security division. And within that, they decided that it was very important that they train all of the prosecutors on how to bring these cases. And so the concepts that you see coming out of the 2012, one of the 2012 anti-money laundering cases against MoneyGram, where the focus really was on the role of the individual compliance officer and this concept that if there's going to be penalties against a corporation for malfeasance, if there's individuals in charge, there's also an expectation that those individuals will be held liable. And so this concept in the anti-money laundering space has evolved to cross over into the sanctions and the export control space. So increasingly what we're hearing from the regulators is that if a corporation has a good compliance policy and procedure in place, it should take into consideration as part of its structure specifically rewarding personnel for good behavior and having clawback functions where personnel went rogue or did something that was inconsistent with the objectives or the corporate culture. And so to a certain degree, we saw that play out in the ZTE case, where the second round of penalties against ZTE largely came into being, or in part, at least publicly, because there was a perception within the U.S. government that the penalties that were supposed to have been imposed against individuals within ZTE actually were not imposed to the extent that the ZTE had promised to the U.S. government. So rather than penalizing the individuals who were deemed to be involved, as we understand, there were bonuses handed out. And so the result not only was punishment for the corporation, but also an expectation that the individuals responsible would feel similar penalties. And so the Department of Justice guidelines for corporate compliance came out just before the Department of the Treasury framework, which was published on May 2nd. A lot of the themes you see are the same in the sense that, and it's also what you would see in the Bank Secrecy Act regulations. So there's an expectation that you have a culture of compliance that's supported from the top. There's a risk-based review done that looks at customer, geography, product, and service. There's risk-based policies and procedures that are in writing that are implemented as a result of the risk-based analysis, and they're designed specifically to mitigate the particular risks. There's compliance personnel who have a level of education and sophistication, not only to understand the specific business profile, but the specific risks. That there's an audit function and that there's training, and that there's also a records component so that all of that is together and tight, and that the reevaluation or the audit function will flow in sufficiently enough with enough regularity so that the program itself continues to evolve. So it's a living document. It's not enough that you have a stack of policies and procedures on your desk. You actually have to implement them. And so a theme that we've seen run throughout anti-money laundering, sanctions, export controls, is that if a company has policies and procedures that are in theory based off of a risk-based program, but they don't actually match what's done, the company can be penalized for not following its own policies and procedures, or for failings in that particular space. So rather than seeing a divergence amongst those four regulatory streams, what we're actually seeing is a convergence. And so what we tend to do, even though the particular areas are very nuanced and complicated, is encourage corporations to move away from siloed compliance functions into a more cohesive approach. Because if you see a corruption problem, chances are there may also be an export controls, a sanctions, or a money laundering issue as well. So if people are trained holistically to spot risks and red flags, you can actually end up having a much better, a tighter compliance program than you would if it was 4 separate programs.
Just one quick thing to add to that. You had asked about what some of the distinctions are, and I think Cari's done a great job to talk about how they converge, and I think that they do. I do think that some of the different regimes sort of play catch up with one another. So I think it was really clear that in the FCPA context, the Department of Justice was pretty developed as prosecutors, and they sophisticated about how they went after those cases against individuals and companies. And there was a pilot program for criminal voluntary disclosure implemented long before there was one from the National Security Division for Export Controls. But now that program exists as well. I've helped one company right now currently going through it. So making criminal disclosures to the Department of Justice, I mean, that program's only existed for, I think, 2 years now in the National Security Division for Export Controls. But it does exist, and it's becoming more mature. Typically in the past, I think criminal cases on the export control side, there's a handful from the State Department against some of the big defense contractors. There was a famous the UTC case. But then they're typically against sort of lower level trade secret theft employees, engineers, people caught at JFK or LaGuardia with a briefcase full of bomb parts and whatnot. I think you're seeing that the Department of Justice is getting more mature in looking at criminal violations of export controls against companies, and the programs and the proliferation of these voluntary disclosure mechanisms and programs in that division is just sort of evidence of that.
Any more questions?
There's a question in the back.
The lady here.
So if nobody asks question, I will follow up another question. So basically, I understand the enforcement actions of compliance penalties differs in deferred prosecution agreement and non-prosecution agreement or settlement. So are there any differences between the enforcement actions in terms of these three forms? Secondly, is there any maybe a trend for multi-jurisdiction enforcement of sanctions, because the sanction schemes may come across with different countries, right? So in terms of current trend of a global family, basically, is there any credit issued by DOJ or OFAC to some of the enforcement actions in local countries? For example, the penalties in disgorgement and the penalties of the target companies. Is there any credit, offered by the U.S. enforcement actions to the local enforcement authorities? Thanks.
So in the anti-corruption space, there certainly has been a long history where there will be multi-jurisdictional cooperation and credit given in cases. In the sanctions space, largely because the United States is the most progressive in its enforcement actions, there's not been a lot of enforcement actions in other jurisdictions. There doesn't tend to be areas where there could be cooperation credit given because of an action in another jurisdiction. In the anti-money laundering space, we're starting to see jurisdictions sharing, largely because under the Financial Action Task Force structure, every jurisdiction that's a member of the FATF has a financial intelligence unit specifically designed so that the financial intelligence unit in the United States can talk to the financial intelligence unit in Hong Kong and can talk to the financial intelligence unit in Singapore. So we have seen in the financial services sector, specifically in the banking sector, an outreach and cooperation in anti-money laundering cases. And I think the 1MDB case is a really good example where you can see multiple jurisdictions, just given the vast breadth of that particular case and how the money moved across so many different jurisdictions. There has been, at least publicly reported, indications that there's been cooperation across multiple jurisdictions. And Chris can talk to the export control space, but I think because the U.S. regime is so different from other jurisdictions, there doesn't tend to be as much cooperation.
Yeah, I'm scratching my brain trying to think of a time where they've cooperated and you've seen credit. You definitely see a lot of attribution of cooperation on the investigation side, right? So they'll talk about working with officials in other countries to help build the case and sort of give them credit in the press release for the action. But I have not. But the enforcement is almost always in my. I'd have to go check. I can't be sure, but the enforcement is almost always led and driven, if not totally done in isolation, by the U.S. The U.S. is the most aggressive enforcer of these types of laws and regulations, and there's not a close second. They take the lead by they lap the field, to use an idiom.
Yeah.
Thank you. I'm with Enterprise Florida, which is the trade promotion agency of the state of Florida. And we're dealing with a lot of small, medium companies in Florida trying to sell products to their Chinese counterparts in Hong Kong. What advice would you give, to smaller or mid-sized companies engaging in or planning on a trade relationship, to basically selling their goods to China? I mean, what should they do given the more complicated situation they're facing?
So there is some credit given in the estimation of the government as to what was risk-based and sufficient as a compliance measure, and they are supposed to take into account the size and sophistication of an entity. A 30-person company is not going to have the same compliance staff as a 10,000 employee multinational company. It's just not realistic, and that's built into the government's calculation of what's appropriate and what's reasonable. So the advice you would always give is you still need to appreciate what your risk is, right? And your risk might come from a number of things. It might come from where your product's going. Is China a risk for you? It might come from the nature of your products. How sophisticated are you dealing? Are you dealing in turbine engine parts, which tend to be highly regulated, or are you dealing in, printed,
Oranges.
printed materials, which might not even be controlled whatsoever in some of these laws? So you need to know your products and know your customers in a way that is reasonable and responsible. The fact of the matter is that if a company like that were to sort of run afoul of these regulations and do something inappropriate or unlawful, there is going to be some measure taken by the government for the relative size and sophistication of the entity. That would be sort of the best news I could give them. However, it doesn't get them entirely off the hook. If they're selling a controlled product, it's their obligation to understand that and proceed accordingly. If they're dealing with entities or customers that are presenting red flags to them, it's their duty to investigate those red flags. And so, one of the cases I'm working on right now is a company that's about 50 employees in the Midwest, and they're subject to very serious criminal investigation right now because small companies can do things quite wrong, and so it's a matter of gauging your risk.
Yeah. So if you were to ask OFAC that question, they would say, has your client, even if the Florida businesses that are selling oranges, so local farmers, presumably small LLCs selling oranges into Hong Kong, have they looked at the framework? And the framework essentially in that particular case would say, to whom are you selling? Does that party look like they should be importing oranges? So if you're selling oranges to an entity that specializes in whatever, the development of silicon chips or something like that, then that from a business perspective, that doesn't make sense and that should raise a flag. But the basic line is if you have a small farm, an LLC selling oranges into Hong Kong, the expectations are that the company, the farmer, would make sure that the party that was receiving the oranges was not on the SDN list. But a lot of what you would do, what the farmer would do from that perspective also would probably be the same steps he would take in order to make sure that his counterparty was actually going to be able to pay the bill. So, adverse media screening, make sure that there's not any indications for fraud, and then basic SDN screening.
Steve?
You mentioned earlier, Cari, a potential conflict between sanctions laws and privacy laws. Could you talk a little bit more about that, and then sort of maybe give some advice on how companies are supposed to deal with a situation where seemingly one country's law is in conflict with another?
Sure. So this arises most frequently with respect to the expectation in the United States from a government perspective that transparency in supply chain, so from extraction of raw materials all the way through to the customer, is perfect. So you want transparency through the whole supply chain. In the European Union, you have an expectation that there's transparency in the supply chain, but it's subordinate to the expectation that individual data privacy rights reign supreme. And so what ends up happening often is that you'll have an export of goods from the United States to the European Union or vice versa, and there'll be an investigation, and the U.S. government will be wanting to know whether the U.S. parties have done due diligence, have collected appropriate information and have screened it. And oftentimes what that will mean is that under EU data privacy rules, the U.S. company will not be permitted without explicit consent or without specific waivers from the data privacy boards in the relevant member jurisdictions from engaging in the due diligence that the U.S. government expects. The other way that we see the conflict arise is where the United States government has submitted a subpoena to a U.S. party for activity that partially involves either China or the European Union or other jurisdictions, and the party sitting in China or the European Union is prohibited under local data privacy rules from providing that information to the United States government. So that's playing out in the courts now with respect to the 3 Chinese financial institutions that have received subpoenas from the U.S. government. The arguments that the Chinese government, that these Chinese banks are making is that they, under local rules, cannot provide that information to the U.S. government. And so we're just waiting to see how it plays out. But that type of fact pattern plays out with some regularity. So what we counsel clients to do is build out the robust compliance program for sure, addressing the export controls and the sanctions risk, and the anti-money laundering to the extent it's a financial institution, the anti-corruption, anti-bribery. But don't forget the data privacy requirements. So when you're building out a program, it does matter where the data is housed and who's doing the screening and how it's transferred. It may mean that, for example, if you're a global financial institution, you're based in the European Union, and there's an expectation that you're going to have an anti-money laundering or a sanctions program, that you do the screening in the European Union and you don't export it to the United States. And so a lot of it has to do with setting up the compliance program before the business is too far along, so that you don't end up inadvertently tripping on a conflict of law scenario.
I suppose, I mean, the issues involved are very complicated, and so, I mean, to me, I mean, I only learned one thing, I mean, which, I mean, when I meet with one of those problems, I better consult a lawyer. Any other questions from the audience? If not, maybe we'll bring it to a close, I mean, of today's lunch sections, and thank you all for joining today's event, and let's again put our hands together and thank you for Cari and Chris. And that'll be the end of today's section. Thank you.